Hi guys, welcome back to this educational podcast. My name is Lauren Howard, and today we're going to be diving into the topic of students' constitutional rights on and off campus. How far can educators go when disciplining while still protecting students' constitutional rights? Let's dive into this together. First, I want to talk about the historical context behind students' constitutional rights, and there are three landmark court cases that we should touch on. The first one is Tinker versus Des Moines. Now, this case established that students have the right to free speech in schools as long as it doesn't substantially interfere with school operations or the learning environment. It all started when students were protesting the Vietnam War by wearing black armbands. The Supreme Court ruled in favor of the students, emphasizing the importance of free speech and freedom of expression. The second court case is Goss versus Lopez. This case tackled the issue of suspending students in Ohio without a hearing. The court ruled in favor with the students, addressing the need to have due process before being deprived of their education. It set the standard that students must be notified of their charges and have a chance to respond and tell their side of the story. The last landmark court case is New Jersey versus TLO, and this court case addressed the Fourth Amendment in schools, establishing that school officials only need reasonable suspicion to conduct searches, balancing students' privacy rights with school safety. So, considering all these cases, we have some legal framework that educators should follow when trying to decide how to discipline. Two concepts stand out: the balancing test and qualified immunity. The balancing test is when courts weigh students' risks with the school's duty to maintain a conducive learning environment. So, for example, in Tinker, the students weren't disrupting learning, they were just wearing their armbands. This is something critical for educators to consider when conducting a disciplinary action. If the students aren't interfering with the learning environment, then they're going to have to weigh the constitutional rights of the student. Qualified immunity is the other legal framework, and this protects school officials from personal liability unless they violate clearly established rights, allowing them to make swift decisions within legal bounds. Now, let's talk about how students' rights can vary depending on the school setting. As government entities, public schools, they're subject to constitutional provisions, and this ensures students' rights to free speech, due process, and protection from unreasonable searches and seizures. Charter schools are publicly funded, but they're operated independently, and this creates a unique legal status for them. Constitutional protections can vary based on state laws and charter agreements. Now, private schools aren't directly subject to constitutional constraints. Students' rights depend on policies and agreements, and they have more leeway to set rules on speech and discipline. Virtual schools face new challenges with privacy, free speech, and accessibility. They must comply with state and federal laws like COPA and FERPA. Now, understanding students' rights gives context to the pressing issue across all forms of campuses in America, and that's cyberbullying. Let's look at two perspectives. Perspective one is protecting students from harm, and perspective two is upholding free speech rights. Both of these perspectives come from the umbrella of cyberbullying. Now, perspective one is protecting students from harm. Cyberbullying can be very severe, creating a feeling of anxiety or depression. Schools are responsible for creating a safe environment, and this can come with addressing cyberbullying even off campus. Some legal considerations to think about is the case of Kowalski versus Berkeley. This case upheld a school's right to discipline a student for creating a derogatory MySpace page because it gave a substantial negative effect on the school environment. So, from court cases and other things, states are exploring laws to expand schools' authority over off-campus cyberbullying. Now, switching to the other perspective, upholding free speech rights, there are some critics that argue that this anti-bullying legislation can infringe on First Amendment rights, especially for off-campus speech. So, some legal considerations with this perspective is the Manahoy versus BL case. In 2021, the Supreme Court ruled in favor of a student who was suspended for an off-campus Snapchat post. This emphasized the importance of limiting school authority over such speech. But overall, my perspective is that educators need to take a stand against all forms of cyberbullying, both on campus and off campus. I myself was a victim once of cyberbullying, and I was able to push through, but I definitely was affected by it, not for the better. Ethically, we must foster a safe environment that promotes empathy and respect, and we are legally obligated to safeguard our students. I think addressing cyberbullying will uphold these values and will set a standard for the community and for learners and educators to come. Thank you.